Greetings, welcome, Jai Hind. I'm greatly relieved that the truth about the Chief Justice of India reportedly refusing to entertain a request made by a lawyer by way of making a mention before him of the atrocities inflicted on the peaceful protesters in Delhi, the capital city of India, Jantar Mantar, by saying that he does not have the time to see videos and the petitioner concerned, the lawyer, should not waste the judge's time and his own time. The media made a hoo-ha about it. Even Godi media reported this matter quite surprisingly, and some of them even made a pretense of being neutral without making any overt attempt to justify the Chief Justice's reactions. Maybe because many of them felt that it was utterly indefensible, because I also felt that way. So I knew that some kind of follow-up statement would be available, and yesterday it has come. The Honorable Judge has clarified, for the sake of the whole country, restoring our full and unfettered faith in the integrity, probity, and sobriety of the judicial system, particularly the Supreme Court of India, that he was completely misquoted by the media. That was only to be expected. The media is such a naughty imp that it's out all the time to misrepresent, especially what the Chief Justice says. And in this matter, let's see what he says. He says that he did not say that he did not have the time to consider matters pertaining to the fundamental rights of Indian citizens, or to take up this lathi charge matter, which included not only lathi charge but also the use of pellet guns against protesters, causing serious injuries to at least 4 people, as reported now by even mainstream Godi media. He did not mean anything of that kind, but that some malicious, malignant media personage gave a horrible, sinister twist to his innocent statement. All that it said was that since the lawyer concerned did not approach the court according to the fixed format, he could not entertain the matter. In other words, had the lawyer concerned made or approached him in the format of a proper judicially worded, formatted complaint, he would have entertained it. So let's now examine this situation. Where does the truth lie? Now, it's very clear, it was very clear to me as I saw this report on India Today. Anisha Mathur, whom I personally know, she is the daughter of one of my former colleagues, goes and attends a very important international event, managed to get the Chief Justice of India on the sidelines and obtained his clarification. On the face of it, it seemed stage managed to me, but that's not the main point. It hardly matters. It is then that the Chief Justice gave this explanation. And when I heard the explanation, I was reminded of what a very famous author, one of my very favorite authors, Arthur Koestler, Koestler, in a book titled The Art of Creation, says. There's a chapter on humor. Very interesting. One of the most illuminating chapters on humor I have ever read is in the book titled The Art of Creation by Arthur Koestler. And I strongly recommend to my viewers to read that chapter. If you can't read the whole book, it's all right, but at least read the chapter on humor. There, he takes up a particular instance to illustrate humor. The instance is as follows. In the days when kings ruled the world, in one of the courts of one of the kings, in those days, the kings had court fools. The function of the court fool was to entertain the king and his audience, the kings and his court. courtiers. So the fool made a statement that sometimes apologizing is a worse offense than the original offense itself. What does the fool say? The fool said to the king, "My lord, sometimes apologizing for an offense done could become a worse offense than the original offense." The king got incensed, irritated. And he said, "Look, you're talking utter nonsense to me. You better prove this, otherwise, you prove it in 3 days, otherwise I'll have your head chopped off." In those days, the kings had the power, the authority to chop off your heads. Even today, our rulers have the right, but they get it done according to the systems using state instrumentalities. So citizens' plight is the same whether it is monarchy or democracy or whatever other crazy it is. So the fool said he would prove it. The first day passed, the second day passed. No proof, no fool. On the third day, sometime towards the evening, the king was sitting on his throne. The fool went behind the throne, stole upon the king, and tickled him immoderately under his ribs. Suddenly the king got very wild with anger. He said, "What do you mean, you stupid fool?" The fool said, "My lord, forgive me, I thought it was the queen." Then the king was very convinced of the wisdom of what the fool was saying, that some apologies can be much worse than the original offense. I was reminded of this episode when I was listening to the clarification offered by Justice Surya, the redoubtable 53rd Chief Justice of India. So now, what is the truth of the matter? I'm sure that the lawyer concerned approached the Supreme Court and made this mention before the Honorable Supreme Judge of the Supreme Court, Chief Justice of the Supreme Court, under Article 32. Now, Article 32 was identified by Ambedkar as the most important article, the heart and soul of the Indian Constitution. When B.R. Ambedkar was asked as to which is the article in the Constitution that he deems the most important article, without batting an eyelid, he said Article 32. And then he went on to say that is the heart and soul of the Constitution. Now, Article 32 is part of what's called Chapter 3 of the Indian Constitution, and Chapter 3 of the Indian Constitution deals with what's called the fundamental rights. Now, fundamental rights, by definition, are inalienable rights. Please understand, it's inalienable rights. Now, fundamental rights are subject to certain laid down restrictions. Rights cannot be denied. Rights is nobody's charity. The citizen obtaining his rights against the state is his fundamental right. It cannot be denied under any circumstance. It is not somebody's charity. It's not a charity of the Supreme Court or the Chief Justice of India to give effect to the fundamental rights of Indian citizens. After all, we are a democracy. Democracy is government of the people, by the people, for the people, and therefore the fundamental rights of the people must be protected at all costs. And that's why Article 32 is incorporated into the architecture of the Indian Constitution. Now let's briefly examine what Article 32 is. This material that I'm going to share with you, I've done a little research on the net, and the result I'm going to share with you. Article 32. Title of that article is Remedies for Enforcement of Rights Conferred by this Part. Remedies for enforcement of rights, fundamental rights. Okay. I'll read only the first two parts of this article. Part 1. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. Guaranteed means there is absolutely no doubt it has to be done. Now, the section in clause 1 that the Chief Justice of India relies upon is the words by appropriate proceedings. Now, I request experienced Supreme Court lawyers, I'm not a lawyer, my legal knowledge is zero. I would request some of them to clarify whether an advocate making a mention before the Honorable Court constitutes an appropriate procedure, or whether, in a crisis situation, a legally formatted complaint has to be submitted. That's point number one. Now let's go to clause number 2. The Supreme Court shall have the power to issue directions without anybody approaching. Without anybody approaching. Clause 2 is very important. The Supreme Court shall have the power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, writ of mandamus, prohibition, quo warrant, etc. So even if nobody approaches the court, if in the wisdom of the Supreme Court, if in the perception of the Supreme Court, an issue, a situation warrants the intervention of the Supreme Court in order to defend the fundamental rights of citizens, it can still issue what? Directions or orders or writs which are binding on the state. Now this is what is called the suo motu powers of the Supreme Court. That is, the Supreme Court taking cognizance of and acting on certain issues and situations which in the wisdom of the Supreme Court warrants such suo motu, that is, without any intervention by other forces, without another party, either a private citizen through an advocate or an advocate directly in his own person, for submitting a formal complaint before the court and then hearing both sides and issuing orders. Over and above all this, the Supreme Court has suo motu powers to issue directions and writs to the state. It's absolutely clear. So when I was listening to Justice Surya, a small question formed itself in my mind. And that question is like this. If in place of Justice Surya, the constitutional chair of the Chief Justice of India were occupied by a justice called Justice H.R. Khanna, whom we associate with that black phase, that black period in the history of Indian democracy called the emergency. My first article was against the emergency. So I know that period, I know what it means. Justice H.R. Khanna had the guts to take an independent, constitutionally sane position against the most adverse circumstances of the times. So the Indian judicial system has had such luminaries. My memory also went back to a judge with whom I had some interactions, Justice Krishna Iyer. If instead of Justice Surya, Justice Krishna Iyer were the Chief Justice of India today, would he have reacted in the manner that Justice Surya has? That was one thought. The other thought that crossed my mind was, has the Supreme Court of India, this very Supreme Court, taken suo motu cognizance of any issues? If there are such issues, what were they? Now, all of us know, and that is quite recently, that this very Supreme Court took suo motu cognizance of chapter, I think, one of the chapters in class 8 social science textbook, which dealt with corruption in the judiciary. This very Chief Justice of India was very active, very, shall I say, effective in issuing instructions, suo motu, address the matter suo motu, and issued instructions to extirpate, to remove the chapter from the textbook. Was it because the judiciary is 100% free from corruption? Does anyone in this country believe it? No. The Supreme Court is very quick to take suo motu actions to preserve its own interests, its own image. There, these procedural proprieties will not matter. The Supreme Court will act post haste. So Justice Surya called it a calculated attempt to denigrate the court. That is, the textbook writer was making a calculated attempt to denigrate the court, and therefore he intervened, the court intervened and defended the court. The second instance, the Supreme Court of India took suo motu cognizance of the stray dog menace on July 28, 2025, last year, approximately a year ago, responding to a newspaper report regarding the fatal dog attacks and rabies, particularly that children developed on account of it. I'm not saying the court should not have, the court did a wonderful thing. That's the right thing to do. So if on the basis of a newspaper report, the Supreme Court of India can take suo motu cognizance of this stray dog bites case, why can't it take cognizance of thousands of our young people, some children as young as 14, 15, 16 being brutalized? I saw some of the spectacles, my blood curdled. And then for the Chief Justice to say that the lawyer concerned did not approach the Supreme Court of India in the right format is laughable. I have to say it's laughable. It's another context in which the Supreme Court, in a very laudable, adorable manner, took suo motu cognizance and acted, was acting on the viral video in the context of Manipur, showing two Manipur women absolutely naked, being paraded naked and assaulted, brutalized by a lumpen crowd. Hats off to the Supreme Court. It filled my heart with tremendous, immeasurable respect for the Supreme Court of India. At another instance in which the Supreme Court of India took suo motu cognizance was in 2020, what's known as the Shaheen Bagh protests. The issue there was that children were being brought to the protest site and displayed. And the court took an exemplary stand in the matter, and I fully endorse the stand of the court. So there are other instances. I'm just giving you 2 or 3 instances to prove that the Supreme Court has the power under Article 32 of the Indian Constitution, and the Supreme Court has been exercising this power to take suo motu cognizance. And therefore, even if the lawyer concerned had not approached the court in person and made a mention of it before this Honorable Chief Justice of India, it was incumbent on the Supreme Court of India, to the extent that it considers itself the vigilant guardian of the Indian Constitution and the fundamental freedoms and the rights of the Indian citizens, to take suo motu cognizance of this issue and to issue appropriate directions to the state, for which it has ample powers. It did not. So therefore, in the minds of the citizens of India, the explanation offered by the Chief Justice will not wash. In fact, the more he tries to defend himself, justify himself, the more laughable it becomes. And that's why I thought it appropriate to quote that instance of humor that Arthur Koestler uses in the book The Art of Creation, in order to explain some fundamental aspects of this very inscrutable, paradoxical phenomenon called humor. It may be of some interest to mention here that one of my areas of interest when I taught literature was literature of humor, including satire. My favorite novelist in the English language is Charles Dickens. And in the American context, it is Mark Twain. There are others as well. Among the satirists, of course, Jonathan Swift, Voltaire in the French context, and so on and so forth. So, as far as the explanation, the alibi, the excuse offered is rather pathetic. It does not carry any conviction as far as the citizens of this country are concerned. I can only hope that the Chief Justice and those who come after them would learn from this experience. An institution as exalted as the Supreme Court of India has to justify the boundless respect that the people of India accords to it by carrying out to the nth degree of perfection the responsibilities cast upon it. Because after all, the respect commanded by an individual or institution depends entirely on its fidelity, its faithfulness, its sincerity and earnestness of purpose. I'm afraid, judged by this standard, there is a lot to be desired. And simply issuing directions to the NCRT or the government that nothing about the corruption of the judiciary should be brought to the notice of the children of this country is not the remedy. The only remedy is reforming the judicial system, upholding its independence, the doctrine of the separation of powers, and making the legal system in this country, particularly the Supreme Court of India, a vigilant and heroic guardian, protector of the rights, liberties, the life and limbs of the people of India. If the Supreme Court of India has no time for it, I'm afraid it does not justify its existence as the third pillar of Indian democracy. I repeat, democracy understood as government of the people, by the people, mark the words, for the people. If democracy is government for the sake of one or two individuals, please don't call it democracy, call it by any other name you like. Jai Hind, Vande Mataram.